Hi everyone, welcome from Law with Dunk the Law Guy, and today is day 34 of the Case a Day series journey, covering cases across criminal law, tort law, contract law and the English legal system. If you ever have a case you want me to cover, feel free to pop it in the comments section and I'll get round to it if I can. In the day 33 recording, I covered the case of R.V. Maloney, 1985, and an earlier, older test used for foresight of consequences known as the natural consequences test. The issue here is that Lord Bridges' natural consequences test misses out the word probable, which had been used within Section 8 of the Criminal Justice Act 1967, where the earlier phrase of natural and probable consequence had been used for an earlier form of the foresight of consequences test. This two-part test in R.V. Maloney 1985 clearly confused the law slightly. Furthermore, it was held in R.V. Hancock and Shankland 1986 that Lord Bridges' failure to include the word probable led to his guidelines for foresight of consequences in 1985 to be defective. In R.V. Hancock and Shankland 1986, the phrase natural and probable consequences test was used instead for foresight of consequences, which we know is strong evidence for indirect intent, which we know is ultimately for the jury to decide. In R.V. Hancock and Shankland 1986, at the time of the miners' strike, the defendants, who were striking miners, wished to block the road of a taxi transporting a miner to work to stop them getting past. So they pushed large concrete blocks off of a motorway bridge, with one of them sadly hitting the taxi windscreen, killing the driver. The defendants argued that they only intended to block the road and not to kill the driver. On appeal, the Court of Appeal actually found the defendants to be guilty of the lesser charge of manslaughter and not murder, which the House of Lords upheld. Lord Scarman went on to stress, which we already know, that indirect intention did not equal foresight of consequences, but that should there be evidence of foresight of consequences, this could lead to a jury finding an indirect intent. In this case, it was held that it was for the jury to consider whether the defendant foresaw a particular consequence. It was emphasised that the probability or chance of the consequence occurring must be taken into account, and the more probable the result was, the more likely that the defendant foresaw it, and the more likely that he could be said to have intended it. You can see that the issue here is that the old test for foresight of consequences used in this case, i.e. the probability of consequences or natural and probable consequences test, assumed that the greater the chance of the victim sustaining death or serious harm from the defendant's conduct, then apparently this makes it more likely that the defendant must have foreseen that outcome upon the victim, i.e. death or serious injury, and the more likely that it was foreseen, the more likely that it was intended, or that this was intended. Way too many assumptions here, which poses an issue with this test. And that's it for today. Thank you from Law with Dunk the Law Guy, and I'll see you tomorrow.